Шановні друзі, шановні учасники,
Dear friends, dear participants, dear guests, please come up here. Dear journalists, we are about to commence our event. We haven't yet started. There will be time for you to take the comments from our esteemed guests. So please take your seats, and please, our speakers, come up here. We will start in 2 minutes. Please come up here. I would like to invite our speakers up here. We have seats booked for you here in front. There are a few more seats available over there. We'll wait for all of the journalists to find spots. We're very happy to see such interest in our event. Dear participants, dear guests, we still have a few more seats up here in front. Please take your seats there. Good afternoon, dear colleagues. My name's Daryna Kaleniuk. I am CEO of Anti-Corruption Action Center. I will be moderating our event. We are here today for a reason. A year ago, a catastrophe took place in the life of the country. There was a Constitutional Court decision that we can say revoked the key progress of the anti-corruption reform. The National Agency for Prevention of Corruption has seen disappearance of e-declarations because Constitutional Court decided that public officials' declarations should not be open, and it became an open-ended question whether public officials should be submitting their e-declarations. As for the reasoning for the decision, the Constitutional Court failed to provide any. And the very prosecution for false information in the declaration was suspended in mid-air. It was a major question what to do with the illicit enrichment as a crime. This was devastating news. Nobody knew what to do with the situation. However, for all of us in the public sector and in the sector of anti-corruption, this was quite a bad news. There was a major protest outside the Constitutional Court of Ukraine. The public was anxious. The Ukrainian people were anxious. It's been a year after that, and today we will be discussing whether the negative impact of the Constitutional Court's decision was dealt with, the decision that took place a year ago. Did we lose anything after this decision? And what should we be looking out for? What dangers from the judiciary, from the Constitutional Court, from other stakeholders? what actions in the context of the integrity of the judiciary. We will start with the opening remarks from the organizer, Mr. Olexandr Novikov, head of the NACP. Over to you. And please be brief. Good afternoon. The 27th of October is forever on the black calendar of Ukrainian statehood. This was a date when the Ukrainian people were deprived of the right to oversee public officials, public service, as a day that presents a hazard to the resilience of our country to internal threats, because corruption is one of the internal threats, and resilience to the threats to our security, because some corrupt states are a key threat to our country. The purpose of our event today is not just to look back at what happened in this year, but also to come up with solutions to prevent similar cases in the future. I would like to thank the EU Anti-Corruption Initiative for their ongoing, long-lasting support and for their support with the organization of this event in particular. Thank you, Alexandra. He will be joining us again later. And I would like to hand it over to Mr. Alan Christensen, head of the EU Anti-Corruption Initiative.
Alan, please, the floor is yours. Alan буде говорити англійською.
Alan will be speaking English. We have simultaneous interpretation and headsets. If you would like to
30 секунд взяти.
put on the headsets, I will give you 30 seconds to do that.
I'm just saying that we are going to have the translation into English, simultaneous translation. It will be possible to understand you for those who don't speak English. Так, всі взяли, хто потребує переклад.
Okay, so I think we have everyone with interpretation.
Thank you very much. Ladies and gentlemen, it's a great pleasure for me to take part in the opening of this panel debate today, and I would like to commend NACP and Mr. Novikov for taking the initiative. And I'm happy to see so many of our partner institutions taking part in the meeting here. This day is an important reminder to all of us, a reminder that the architecture of anti-corruption institutions in Ukraine is fragile and may be jeopardized by a single event, a court ruling, as was the case on 27th of October last year. The ruling by the Constitutional Court had far-reaching implications. The important e-declaration system was shut down, NACP lost most of its powers, and cases being investigated were terminated. Ukraine was in breach of its international commitments. This time, the anti-corruption architecture was rescued, thanks also to a strong engagement by the civil society and by Ukraine's international partners. But it was close, and there might be a next time. As we know, currently, the Constitutional Court of Ukraine is considering a motion regarding the constitutionality of the law on the High Anti-Corruption Court. Last autumn, the EU ACI, my program, together with our international partners, supported the development of an amicus curiae brief by highly reputable international and national experts. We hope this document has helped to facilitate the legal debate about the constitutionality of the law. The threat to independent and well-functioning anti-corruption institutions comes from different directions. Are the institutions going to be successful? They need professional leaderships that are independent. With two selection processes ongoing, head of SAPO and head of ARMA, and one upcoming head of NABU, there's indeed a need once again to stress that these selections must be transparent and merit-based. And we stand ready to support and facilitate processes that live up to these criteria. We welcome in that regard the new NABU law that provides a good framework for the NABU head selection. And having with us Mr. Novikov, I think the selection of the head of NACP is a very good example to follow. Finally, I would like to emphasize the importance of the national anti-corruption strategy. It has been missing since 2017, and without it, Ukraine lacks a strategic framework, and its government institutions, they lack a direction. An ambitious draft strategy was prepared by NACP last year. I believe it will create a new momentum in the fight against corruption, and it will further safeguard and consolidate what has already been achieved. It will strengthen the anti-corruption architecture. Now the Parliament has to act and approve the strategy. Thank you for your attention. I wish you all an interesting and fruitful debate. Thanks a lot.
Thank you, Alan. Дякуємо Алену за підтримку.
Thank you, Alan, for your support. This event is supported by EU anti-corruption initiative. We're going to have almost 2 hours of intense work and discussions with esteemed guests. We will break the discussion in 2 parts, and first I will invite the representatives of law enforcement and the judiciary who maybe fell victims to the decision of the Constitutional Court, and they will share with us what implications this decision had and whether these implications were rectified and whether they are afraid of the future. And after that, we will talk to politicians, the representatives of the parliament. We have a representative of the Parliamentary Anti-Corruption Parliament. We have Olga Sovhira, People's Deputy of Ukraine. We have Minister of Justice, and there will be representatives of civil society organizations, and there will be opportunity to ask questions. So I'm inviting to the first part of our discussion Olexandr Novikov, Artem Sytnyk, the director of the National Anti-Corruption Bureau, Danila Chernenko, the head of the High Anti-Corruption Court of Ukraine Appeals Chamber, and Kateryna Butko, head of Avtomaidan organization, and also head of public counsel at the NACP. I think that we'll start with Olexandr Novikov, even though we already heard his introductory remarks. The public felt the implications of the Constitutional Court's decision immediately because NACP closed down the declarations. What happened after this decision? Let me share one interesting fact with you, how NACP learned about this decision, and also I'll share why it's important to prevent the similar from happening in the future and what needs to be done to prevent it. On the 28th of October, so the next day after the Constitutional Court decision, nobody knew that this decision was out there. And on the evening of that day, Ukrainska Pravda and Sevgil editor-in-chief, was making a movie about the history of anti-corruption institutions in the building of NACP. And during the shooting, my assistant brought me the decision of the Constitutional Court, still warm. And every one of you can look up the Ukrainska Pravda movie on the YouTube channel, and you can see the moment. Sevgil Musaeva, the editor-in-chief, and I were reading this decision and realizing what impact it would have and how it would benefit corruption. So when this movie was being made there was enforcement document prepared to enforce this decision, and NACP has to do that. This is in line with the law, and there used to be a provision that we provide access to the public for the e-declarations, and this provision was revoked. And a year after, many consequences were dealt with, specifically with support of the National Security and Defense Council. On the 29th of October, the government was instructed to provide public access to the register of declarations, and NACP was provided with access to other registers of other institutions that helped proceed with appointments to offices. We've been hearing from judges a lot about problems with appointments of judges, but this constitutional decision actually had this process suspended because all of the judges were going through the vetting process, so it wasn't possible to proceed with appointments. And NSDC had to tackle the Constitutional Court decision. So there was a first decision that unblocked the access to declarations. There was another decision asking the parliament to pass a bill to alleviate the situation. And a third decision of NSDC was about a criminal case that was investigated. And the decision recommended to suspend the president of the Constitutional Court by the president. But we cannot say that NSDC played a major role only after the 27th of October. Other tools that were enshrined in the Constitution and the laws, they unfortunately failed to work. They weren't able to protect the constitutional state from such a major issue that was brought about by this Constitutional Court decision. Nonetheless, I should mention that not all of the consequences were dealt with. Over 4,700 of the cases and many of the NABU cases, every fourth conviction, every fourth verdict of the High Anti-Corruption Court, if I'm not mistaken, went under devastating consequences. The persons that committed criminal offenses, unfortunately, were managed to evade criminal liability, and Hack, unfortunately, had to revoke the verdicts that were there at the moment. This is something that we couldn't restore. So why this decision mattered, and why did the public only learn about this decision from the website of the Constitutional Court? Why this decision wasn't in line with the submission that the court received from 45 MPs? We still do not have a law on the constitutional procedure, and without this law on the constitutional procedure, it is impossible to anticipate the decisions of the Constitutional Court. Constitutional Court in this decision virtually intervened with the authority of the Parliament, overtaking the Parliament's powers, and unfortunately there's not a single safeguard protecting us against similar decisions in the future. So what you're saying, you're afraid of having similar decisions in the future? Yes. If I may, I would like to interrupt you to have a lively discussion. So the question is, a year ago, did we have amnesty for public officials for false information in a declaration? That is true. Constitutional Court relieved those who had false information in their declaration from liability. Thank you, Olexandr. I would like to hand it over to Artem Sytnyk, the director of NABU. Do you agree with Alexander's opinion that this was relieving public officials from liability for false information in their declarations? As of now, anti-corruption bodies are in unity, so I couldn't agree more. Of course, that is true. And this was truly sort of pardon, amnesty, or decriminalization. We can use different words here, but one way or another, this helped those who committed criminal offenses evade liability. What did you lose? How many criminal cases were closed due to this decision? Well, Alexandr gave the number of the cases, 4,712. Well, there were a lot of cases against high-ranking public officials, but that's not the point. If you dig deeper, in your introductory remarks, you mentioned that a catastrophe happened. The thing is that we've had one catastrophe after another, one disaster after another. And in February 2019, the law specifying criminal liability for illicit enrichment was recognized as unconstitutional. So this was the beginning of it all. And the response to the issue was quite feeble, because this was the first decision of its kind. And political elite obviously was in favor of that decision. After the first wave of e-declarations, we saw so much money in the declaration. So it was quite something that we expected. This decision. And so the first cases were closed back then against some notorious people, in particular people from Prosecutor General's office. And after the judiciary reform, for the first time ever in Ukrainian history, a case was won, a case submitted by NABU, a case against one of the oligarchs. I'm not going to give the names to minimize the number of the lawsuits against me. That was decision involving Ukernafta company, and the case went through the first instance trial and the appellate court, and there was a submission to the Constitutional Court, and the court recognized that NABU has rights to file unconstitutional to submit lawsuits. And the next that happened was recognizing the appointment of the director of NABU as unconstitutional. This was quite an interesting decision. Throughout the entire history of the Constitutional Court never assessed the individual action, because it doesn't make sense, and revoking the action itself doesn't make sense. But from the political standpoint, it made a lot of sense. And then there was a decision about some provisions of the law on NABU, then the decision that we are discussing. So there were decisions of the Constitutional Court that inflicted devastating blows. And we can see sort of a system here. As soon as an anti-corruption tool starts working, then you get a decision from a Constitutional Court. So the problems that led to that happening, the lack of political will, the absence of the procedure that Olexandr referred to, well, yeah, that is the case. So saying that there will be no similar decisions revoking liability for other things is something I cannot say. Well, there's a very transparent system right now, and public officials are very open. Anyone can see them. And there have been a lot of investigations. A lot of people became politicians, and we can see that there are often discrepancies. If you look at their legal income and what they put in their declarations, it raises a lot of questions. And the absence of strategy is a major problem. Some laws are adopted. They enter into force, and it's a bit chaotic, this political struggle. And given this is chaotic, we see the absence of the mechanism. Everything looks great on paper, but when it all starts working, we see that we cannot anticipate the resistance from political forces. Well, it looks like the oligarchs are the ones that have strategy, and our northern neighbor. I have a quick question for Artem. Were all the consequences dealt with? There were a lot of drafts that returned, reinstalled some provisions. Well, there are two types of consequences, something that is reversible or irreversible. So some things were dealt with, but once again, let me reiterate that I cannot say that similar things won't happen in the future. And there are some irreversible consequences. After the decision, the question was raised, is it lost forever? There are things that were lost forever. And in order to prosecute someone for illicit enrichment, well, first you need to let them steal money. because what was stolen before the decision of the Constitutional Court is not covered by the law. Regarding the declarations, I'm very happy that we managed to adopt a law that helps assess the declarations of the 2020, because there was risk of losing those declarations. Thank you. Let women speak. It's not just losing cases for 5 years. It's losing 5 years of life of every citizen of Ukraine, of living in a non-corrupt country. Daniela, Artem said that the appellate chamber of the hack, there's some threats to it. So how do you see the decision that took place a year ago? What's the implications for hack, for anti-corruption infrastructure overall? And are you afraid of the future, maybe? Good afternoon, everyone. I think that the appellate chamber has less powers, and NABU knows more about us than we do ourselves. This is the first time I'm hearing that there are threats to the appellate chamber, that there's intention to terminate it, that there's talk about recognizing the law about hack as unconstitutional. Well, I think that back when we submitted our applications to be selected to hack, we were well aware that this is going to be some hard work, so we needed to deal with our fears. That's answering your question about fear. And if we read the submission that's pending before the Constitutional Court, indeed, there are some peculiarities to it, but I don't think we should be afraid. If someone believes that there's something that gives ground to see this law as unconstitutional, maybe there could be a draft law, a law adopted to help resolve the situation as long as this decision is pending. You're a lawyer, so what do you think? I'm a lawyer. Are there threats there? Well, if we go provision by provision, I don't see any threats there. If you're asking about the appellate chamber, then the question is who is going to be hearing cases? If we only have the first instance, no appellate instance, who will be doing that then? Well, it depends on the parliament, if indeed that is going to happen. Well, the only thing to mention about the institutionality of hack, well, we are one legal entity, but the appellate chamber could be given powers of a separate legal entity, so we can deal with that in this way. Regarding losing hack, I wouldn't even be using this word, because whether the public likes it or not, the decisions need to be enforced, and we have to respect those decisions that enter into force. We are under obligation to comply with court decision. The cases that hack had, that the appellate chamber had, these cases were closed due to the unconstitutionality of the law. Did you have to close many cases? No. We had 3 cases. We finished hearing them, and the Supreme Court was officially closing those cases. A last question for you. You said in very diplomatic terms that the court, your court, has to comply with the decisions of other courts. However, we, the public, are trying to understand the reasoning behind the Constitutional Court decision. Would you say that the court decision needs to have a court decision? And did you see that reasoning in their decision a year ago? Well, you insist on me stepping away from the principles of the judiciary ethics. I'm sorry, but I'm not going to do that. I stand by the ethics. So we have a master class from the judge of Hack how to deal with the pressure. Kateryna Butko, Avtomaidan activist, head of public counsel at the NACP. What did the public think about the Constitutional Court decision? What about your fears about the future? Well, as it was mentioned before, a year ago, we had a very dark day for the entire country because the hopes that we had for 5 years for fairness, they were buried. And about the public and how the public responded, we need to remember how many people came to rally outside the Constitutional Court building. And these were people that don't often come to various rallies, but there were hundreds of people who took it to the streets because their hopes for fairness and justice and their hopes that the officials line in the declaration, their hopes for Euro integration future that was threatened by this decision were killed. And this was the most visible response from the public. It was shocking for them. The saddest thing is that even though the event took place a year ago, the constitutional crisis haven't been resolved. And as the previous speakers have mentioned, the threat is still out there. And we cannot be sure that tomorrow the Constitutional Court is not going to kill e-declarations again, or anti-corruption court, or the new judiciary reform, similarly to what they did before, and they can do it again. And this threat is still there. And we could say that this is a matter of people, those who work for the Constitutional Court, but it's not only about people, it's about the system, how those people get there in the system. And the most important thing to resolve the constitutional crisis is to change the very procedure of selecting the Constitutional Court justices, because one way or another, these are political appointments, and these people are just doing what those who appointed them instruct them to do. But this cannot happen this way, because this is the highest court in the country, and their judges have to be selected through an independent and transparent procedure. And this was mentioned to us on more than one occasion by the public, by the international experts. However, the draft laws that are pending before the parliament do not have the provisions that would specify this selection procedure. So it's not only the people that have to change, it's the system itself, the system of appointing Constitutional Court justices. We need to have the court that would be provider of justice and protection, instead of waiting for next reform and seeing our hopes killed.
Right, you are. Kateryna just mentioned that actually there was this aspiration, right, to have other reforms, language reform, land reform, banking reform. And Olexandr, you wanted to mention something. Right, you are. I wanted to mention that there is a positive effect of this resolution of the Constitutional Court, because actually it protected what is very important for the state, the High Anti-Corruption Court of Ukraine, right? And now this body is more protected, but not just High Anti-Corruption Court, but all the other reforms and judicial reform of today is being protected by this decision of the Constitutional Court. court and joint participation of President, of the Parliament, and of the civil society. And two more remarks from me. This very decision has shown the bias of all the previous decisions, right? So now we clearly see what was going on, and the Venice Commission has recognized that our anti-corruption legislation complies with all the international standards, meaning actually this protection, of course, shall be strengthened by the adoption of the anti-corruption strategy of the country. But why is it still dangerous? The system may change, because so far we don't have the law and the constitutional procedure, and judges of the Constitutional Court and other courts can actually pass their decisions regardless of the conflict of interest, which is why NACP has resorted to the President of Ukraine to pass the law on the constitutional procedure, as well as adopt some amendments to Article 133. Kateryna, your organization is dealing with what? With the analysis of the assets of judges. Have you analyzed the assets of the judges of the Constitutional Court? What motivates them? Well, we were, of course, analyzing their assets, and we were also paying a visit to the head of the Constitutional Court. And I believe those representatives of media, those people who were traveling with us, they saw what motivates for these decisions. So that's just this huge fence and the huge house behind that huge fence. And while sitting there, a person feels impunity, right? Because they want to build more, to have a bigger house. And for that purpose, they need to pass decisions which are dictated to them, which can actually yield some more profits. And for a judge who all his or her life were working in this system, and they were working for 20 years, for example, it's not possible to build such a house, even if it's not their house, but their mother-in-law who lives in Donetsk. So there are plenty of questions as regards independence of Mr. Topitsky, for example, because his close relatives are residing at the occupied territories still, even nowadays. And also there are questions as regards assets and wealth of other judges of the Constitutional Court. I'd like to actually tell you that regardless of the fact that the author of the decisions, Slidenko judge, actually asked to be to retire, still he's not fired. He still works in that court, and we are paying taxes which are paid to him as a salary. So I believe this is not very logical, and this is not right. Thank you so much, and I would like to ask the last question to Mr. Olexandr, and then there will be opportunities to ask questions from the hall. So then we will summarize the first panel discussion, and then we'll invite representatives of the second panel discussion. So the decision of the Constitutional Court, wasn't it a revenge or desire to stop an NACP, right? Because an NACP is entrusted with the function to verify the assets, to check the assets and their legitimacy. Well, it's obvious for us. We were publicly discussing this decision of the Constitutional Court, and we were claiming that 3 judges of the Constitutional Court who were not reporting about their land plots, and also Topitsky was asked a question as regards buying some property in the Crimea. Yes, there was this conflict of interest, and according to Article 60 of the law on the Constitutional Court, of course, they could not veto this. But as of today, the law is formulated in such a way, regardless of the fact that cannot consider the case, they are still considering the case, which is why we need to do something with this Article 60 and Article 133. Because actually any judge, even having a conflict of interests, may actually pass any decision, even if there is a conflict of interest. Venice Commission mentioned it directly. Regardless of this, judges from the Golosiev court, they actually didn't do a thing with their colleagues. Venice Commission was mentioning the conflict of interests, but our judges did not take that into account. They are not taken into account, this association of all the judges from the civilized countries of the world. And today we have verified the declarations of all the judges of the Constitutional Court. In two declarations from 2020, we saw actually the reasons to launch criminal cases because they were providing untrustworthy information, Litvinov and Kravchenko judges, but this was not a revenge, you know, to NACP. This was a revenge to High Anti-Corruption Court, because actually majority of the criminal cases considered by High Anti-Corruption Court were the cases which were related to identifying false information, or providing false information in their declarations, and it was actually a revenge to NABU, because NABU was doing their job in a great way. So the corruptionists were not afraid of the process, and I'm proud of the results of the work of NABU and High Anti-Corruption Court. And you know, they were hitting us, but it didn't work. And I would like to give the floor to Artem Sytnyk now for a short remark, because two criminal cases were mentioned, right? As regards judges of the criminal court, I don't know whether you can comment on it or not. I wanted to add a few words as regards motivation, why it's happening like this. You mentioned two family names, and actually, yeah, we shall do something with lies in the declarations. I don't want you to use the word revenge, right? Because there will be some artificial conflict of interest if we use this word too much. I just want to tell you why is it happening like this. We received recordings from one of the rooms of one of the judges. And actually there was this embezzlement case, and they were discussing in that room that we need to do something because they may actually blame me of embezzlement. And then, when the notice of suspicion was signed, and there was also Article 175 involved. Yeah, they gave the red light again. So unfortunately, we see that there is some beneficiary, or plenty of beneficiaries, to the decisions of the Constitutional Court. And some influential people are interested in certain decisions. That's a problem. So this is not a problem who is revenging on whom, but the problem is when some tool starts working, then plenty of obstacles appear on the way, right, in the form of these decisions of court. Let me guess in whose room it was. Maybe it was Vovk judge room. And let me also guess what kind of oligarch you are speaking about. I believe it was Ihor Kolomoisky. Right, and do we have any questions from the hall? At first you, then you, please. And you need to take a microphone. Tell us, please, what to do. Shall the mic come to the speaker, or speaker can go to the mic? So, please. Use the microphone and introduce yourself. I'm Lyubov Velichko, journalist of analytical portal Slovo and Dia. I have three questions to three representatives. At first, to Mr. Olexandr. Tell me, please, do you believe that the public council by NACP has got the sufficient mandate? I was communicating with the representatives, and I learned that being member of that council does not mean seeing all the work done by NACP. So these public council representatives do not see all the work of NACP. And are you ready to provide members of this public council with a greater mandate in terms of access to some working current documents for them to see more and understand more how you work. That way you will be more transparent. Then, another question. Mr. Novikov, in his interview to Slovo Dilo, mentioned that judges do not understand in what way they shall properly interpret legislation on liability about failure to declare some assets, which is why a question to you. Do you understand in what way to consider these cases, and whether colleagues from your court understand in what way to consider these cases? And a question to Mr. Artem. We know that the protocols NACP is actually giving to the police is shocking the investigators. Investigators do not know what to do with cases like that whenever there are some violations with the declarations. And what about your subordinates? Do they understand in what way to deal with these protocols, or they are at a loss sometimes as well? Give us a frank answer, please. Okay, who wants to start? Well, speaking about NACP activities of all the officials, we are open and transparent to the maximum amount possible, and we are ready to provide all the information stipulated by the law to the journalists, to the public council, etc. Maybe we shall ask the public council itself. I should tell you that actually the goals we are pursuing as a public council would be really to have an NACP as a very open body, as a very transparent institution, right? And it shall be transparent to each and everyone. Public council members will be replaced by other people, and we are highlighting all the time that all the documents shall be there in open access whenever it's possible, and I hope it will be like that. Mr. Olexandr, so are you going to be more transparent? Are you going to make public more and more documents? We are making public all the documents according to the law. I know there are some questions of certain civil society organizations which are not part of the public council as regards certain documents, but you know there are certain documents which are there just for internal use in order to protect certain people from the aggressor country. Thank you for your question. Ms. Danila. Mr. Olexandr is saying he was not telling it to you, but as far as I remember, I was reading something like that. So, if it were not his words, he shall be reading the interview he gave. Then, speaking about right to personal opinion, well, of course, we can not, blame him of that. Everybody has a right to assess it their own way, and I believe journalists are assessing the transparency, right? And the journalists understand whether the representatives of NACP are experts in something or not. That's the personal opinion of Mr. Olexandr. So you asked about you asked my opinion about the High Anti-Corruption Court. Well, I believe they are dealing great in terms of plenty of criminal cases, which is why, some articles were announced null and void. They are good friends here, and you would like them to become enemies. But Ms. Danila didn't answer whether you know how to properly consider these cases. Well, the thing is that failure to declare assets is a crime. I don't know what can be the problems in this situation in terms of considering these cases in High Anti-Corruption Court. I haven't seen that judges have some problems while considering these cases, right? There's never some third opinion, or I haven't seen the situation when judges are quarreling whether that's an asset or not. So today there was this event, High Anti-Corruption Court, and one of its chambers, for the first time in the history of Ukraine, considered the case of Ilkirev assets, and actually this very decision decision is now passed, and that's for the first time in the history of Ukraine. You know, now he has to pay fine for failure to declare. Yes, and have I answered your question? Okay, now Mr. Artem. May I also add to this very issue? It's not possible to break our friendship because we've lived through so many things together. Speaking about the new tools, yes, there are always some discussions as regards the use of these new tools. I'm answering your question now. You asked whether we are cooperating with NACP properly. They are not sending us protocols. They are sending us some conclusions with great rationale. And I think back in what way we were cooperating with NACP before 2019 and after that. For example, when we were providing NACP with our materials and NACP were disregarding these materials, now the cooperation is on a new level. Let me briefly tell you, because this is not a secret at all. When NACP start implementing their mandate as regards checking up the declarations, they, using their opportunities, access to registries, they start conducting this verification, this checkup. And proactively, they are asking us whether we have anything on that person. This is something which is quite a legitimate procedure. And once again, we exchange this information very proactively, and we are providing the information whenever we have anything. And when, in the course of a full-fledged verification, NACP sees the reason to believe that there are signs of the criminal violation, then they are sending us appropriate conclusion, right, to NABU, and detectives are considering this very case, whether to register or not to register it as a case. And before it all started working properly, the heads of NABU and NACP had this working meeting with all the detectives, with the heads of departments. And we've developed these common approaches to assessment of a certain, I don't know, even terminology. What is a house? What is not a house? What is Bitcoin even? Right? We were defining what assets are. We wanted to develop this common understanding. And actually, I cannot tell you that everything works perfectly now, because sometimes there are some confusions, misunderstandings. But we are working on these unified approaches to assessing certain actually conditions, cases, and this is something new whenever new tool emerges, but I believe we will actually learn in what way to cooperate even in a better way. Both authorities are very open for this mutual cooperation.
So the investigators are well versed in investigating those cases. Well, I'm not quite sure about the investigators from the national police, whether they are experienced or not, but our investigators started working in that area way back in 2016, when we still had illicit enrichment as a crime. And there were heated debates with prosecutors, because that was something new. Well, and actually, we had to learn it the hard way, because there were all sorts of investigations. You take the case to the court, and there are decisions, verdicts of appellate courts, and then you get the Constitutional Court decision, and this all is in vain. So that's probably the most demotivating for our employees, because given that they have this experience, we'll be investigating the cases again, and then we'll end up having the same thing. Thank you. If I may, I'd like to have a remark. Could you be brief about unity of law enforcement, since you put us in this category? Well, you should see them when they see the acquittals or when the motions are denied. You should see them. Well, the court is administering justice. Court is not fighting corruption. Of course, we have criminal cases, we hear cases of corruption offenses, but it's not the same thing. Thank you, Danila. One more question. and then we'll have final remarks, and then we'll open the next panel discussion. Oleg Novikov from Slovo Idil. I have a question to Artem Sytnyk, head of NABU. You mentioned the recordings from one of the court presidents from Kyiv District Court, and there were mentions that their actions have to do with Constitutional Court. There was investigation by Slidstvo Info about appointment of the court president and so on. Is NABU investigating that, about appointments of the court president? Is there a criminal case? Let's take one more question while Artem is thinking. Could you introduce yourself? Vyacheslav Replov, Sudovo-Yuridicna newspaper. I have a question for Mr. Novikov. I have a question about the conflict of interest. I was watching the parliamentary meeting, the faction, and then I saw Mr. Novikov speaking before them. But maybe going to these political events, this is a conflict of interest. It was not a governmental event. It was a party meeting of the president's party. No more questions? Is that correct? Okay. Then over to Artem and then Olexandr. I think Alexander should go first. Well, I'm ready to take the question. A year ago, the president said that anti-corruption strategy is an immediate task, and the government recommended the parliament to adopt it in August. Until now, we don't have the anti-corruption strategy of the government, the parliament, or the president, which means that a corruption strategy is being implemented. This might sound weird, but I presented the anti-corruption strategy to Batkivshina party. I submitted the strategy. I submitted the strategy to Opposition Platform for Life party, to Holos party, to Ms. Kira Rudik and other MPs of the faction. However, given that the servant of the people is so large, I didn't have an opportunity to present the strategy to the mono-majority, the majority in the parliament, that has a majority in the parliament. So I used the event that you were talking about to present the anti-corruption strategy and the way it is going to impact the lives of people and what it will mean for the mono-majority. And a year ago, there was recommendation to adopt the strategy by the parliament, but until now, for some reason, the parliament hasn't done it yet. We know about the circumstances that you're talking about. We looked into that. And we looked into whether that was an offense, but we learned that another law enforcement body is investigating the case. We asked to have the case transferred to us, but it wasn't done. So I don't know about the decision in that case. Thank you, dear colleagues. We'll be wrapping up this discussion, but the next panel is going to have politicians, the Minister of Justice, head of the Parliament Anti-Corruption Committee, representatives of civil society organizations, and they need to make certain decisions to prevent disasters in the future. So what are your expectations for the politicians? What decisions need to be made to prevent Constitutional Court from revoking or dismantling anti-corruption reform? A minute or two. Let's start with Kateryna. Well, I already said before that the crisis cannot be put on hold. It had to be dealt with, and we need a law on the Constitutional Court. We need the amendments that would specify the clear and transparent selection procedure, and it has to be done as soon as possible, because otherwise we risk seeing the similar decision of the Constitutional Court, and the Constitutional Court has been showing us they are capable of doing that. Two things to say. First, adopt an anti-corruption strategy that would set out the vision, well, for the Constitutional Court about where the country is moving. And the second, the law about anti-constitutional procedure, because the changes that were reached after 2019 could be destroyed in an instant. Well, you know more than I do. If Artem said that there's a threat to have the appellate chamber dismantled, well, it would be great for the parliament to make a decision about that. And if there's talk that we're a special court, even though I cannot say that this is the case, we are better provided for in terms of the accommodation and apartments, because other judges can privatize the apartments, but we cannot do that. And investigating cases, aside from criminal cases, we have civil cases as well. So it's a matter of jurisdiction, and there could be amendments made as well. About economic crime, about who will be dealing with those cases. So there has to be a decision about the appellate chamber, is there a threat or not? And there has to be amendments made to the Criminal Procedure Code specifying specific reasons for non-hearing some cases. A few months ago, I participated in discussion of amendments to the Criminal Procedure Code, and this is a burden issue because there are pending criminal cases without movement, and everybody knows what the reason for. If the defense doesn't want to have the case heard, it can last for years. If the CPC remains the way it is now without amendments. In 2010, the Constitutional Court of Ukraine amended the constitutional structure of Ukraine from the parliamentary and presidential republic to presidential and parliamentary, putting emphasis on the president. And the judges who made a decision, they are part of the decision that we're discussing today. So the right thing for those who are making decisions in the parliament and other institutions is to analyze all of the mistakes that were made and to take action to prevent these things from happening in the future. And one more thing that I can say, if these measures are political rather than legal, this could have quite an adverse effect. Well, we call them political and legal, those kind of measures. Well, we'll discuss that separately. Thank you, dear speakers. This concludes our panel discussion. Please find your seats in the audience. And I'd like to invite Ms. Olha Sovhyra, People's Deputy, Member of Parliament, Representative of Parliament to the Constitutional Court, Ms. Anastasia Radina, Head of the Verkhovna Rada Committee on Anti-Corruption Policy, Mr. Denis Maluska, Minister of Justice of Ukraine, Stepan Berko, DEJURE Foundation, civil society organization. Dear colleagues, you heard from anti-corruption institution, the judiciary, civil society organization, about how the Constitutional Court decision was perceived a year ago. Each one of you, in one way or another, was part of finding solutions to the crisis, all in different ways. And I would like each of you to comment what was done and where you are now. So the risk is not mitigated. As far as I understand, the crisis is simply deferred. Should we be waiting for another disaster? I suggest we start with Anastasia Radina, head of the anti-corruption committee, because we've been talking a lot about the anti-corruption bodies that suffered from the decision of the Constitutional Court. Anastasia, what was done? Were the negative results rectified, and what should we be bracing ourselves for? Thank you very much. Well, I'm very happy to tell you that as far as the anti-corruption infrastructure is concerned, the Parliament restored anti-corruption legislation and passed all the laws necessary for the anti-corruption system to function, for all of the authorities to have the powers and independence, and the Parliament did it with dignity. The Parliament restored the powers of NACP as far as vetting e-declaration is concerned, and restored other powers that suffered as a result of the Constitutional Court decision. And this was not an easy thing to do. I was a member of the working group that was working to restore legislation after the Constitutional Court decision, and parts of the decision were written in a way that was impossible to understand why specific legislative provisions were unconstitutional. So we had to venture a guess what was the reasoning of the Constitutional Court. And in some cases, it was impossible, because there was zero, and it's not an exaggeration, zero reasoning about unconstitutionality of the said provision. A week ago, the Parliament passed amendments to the law on NABU that was a response to Constitutional Court decision about unconstitutionality of the previous model of appointment of NABU director to office. We specified that NABU becomes the central executive authority with special status. At the same time, let me emphasize, we also specified all the necessary independence guarantees for this body, the status, independence of the appointment procedure. Independent experts are going to play a key role, and the Cabinet of Ministers will not be able to intervene with the organizational aspects of the NABU's activities. And I see this amendments very positive. Criminal liability for illicit enrichment was brought back after the decision of the Constitutional Court of 2019. The criminal liability for false information in the declarations was brought back as well. Nonetheless, the Parliament couldn't do anything in line with the Constitution to restore the chances for prosecuting those persons that, through the decision of the Constitutional Court, were virtually pardoned for the illicit assets. So the Parliament did their best to restore the legislation on anti-corruption institutions and prosecution. A brief question. Any fears that you maybe have for the future? Because we've heard that there's still threats. And as the head of the parliamentary committee, do you think that maybe the court could render a decision to dismantle the appellate chamber of Hague? Is there a chance of that? Thank you very much. Constitutional Court still has pending the decision for liability of illicit enrichment and civil confiscation on unsubstantiated, unjustified assets that leadership of anti-corruption bodies were talking about. And there's a pending case in Constitutional Court about the law on hack, and I cannot exclude the new, let me put it the right way, I'm having a hard time choosing a word, the new series of Constitutional Court decisions. And I'm worried about the hack decision pending before Constitutional Court. I'm not quite sure what we can put in the law specifying that an appellate chamber is a legal entity, because the law on the judiciary does not include a separate chamber in the judiciary. There are courts, not standalone chambers. And the decision about unconstitutionality of the Chamber of Appeals of Hack, even though I do not see anything unconstitutional there, nonetheless, such a decision could be a point of no return, because in that case, building an independent appellate instance in anti-corruption court would be either impossible or very, very hard, and it would threaten anti-corruption cases for years. So I cannot say that I am happy with what might happen with hack because of Constitutional Court. Now I have a question for the Minister of Justice. Daniela used very diplomatic terms to say that she cannot assess the reasoning of other courts, but you're a lawyer, the Minister of Justice. You an expert in law. So as a Minister of Justice, what did you think about the Constitutional Court's decision that stopped e-declarations? Thank you for the question. Well, it was raised on more than one occasion. Of course, neither me nor my colleagues did not see any proper reasoning in the decision. We said that right away, and there were a lot of discussions. But this was a logical development if you look at the actions of the Constitutional Court. Constitutional Court acted as a small child. A small child is trying, is this going to work? Is this going to work? So until there are restrictions, until, someone slaps you on the wrist. So that was the case when the Constitutional Court reached a line, when they were told that this is not the way to proceed. Probably the Constitutional Court heard that because that freight train of destroying anti-corruption reform stopped, went to a halt. And the thing is that the Constitutional Court turned from a classical court with lawyers into a political body in which any important reform went through yet additional reading after the readings in the parliament, with much meticulous, scrupulous juggling of two articles of the Constitution, Article 6 and 8, about the separation of powers and the rule of law. The interpretation of the rule of law let them destroy pretty much anything. And having realized the power that these articles give them, and having realized that there's no mechanism to hold them liable, the Constitution is written in a way that they are rulers of their own fate. All of that caused the constitutional crisis. Regarding the dangers that could be generated in the future, of course, such dangers didn't go anywhere. There are no clear mechanisms of liability for the justices. They weren't there in the Constitution, and there aren't now. And what's implemented right now are some mechanisms of deterrence, mechanism aimed at mitigating the risks, aimed at making the court more balanced in their decision, mechanism of additional oversight of the procedure and safeguarding of the decisions by the opinions of the Venice Commission. This is all good. This mitigates the risk of some weird decisions in the future. But nonetheless, this is not 100% guarantee. the constitutional crisis is going to be over after there are amendments to the constitution. Regarding response to the previous crisis, it was good, it was very telling. All branches of power supported the restoration of anti-corruption mechanism. It all began with the decision of the National Security and Defense Council. Probably that was the beginning of their soaring flight. This was one of the first public activities that they had that was about the decision of the Constitutional Court about the anti-corruption reform. There was a decision restoring the access to registers for NACP. There were a few laws that the parliament passed. In particular, those that specified prison term for false information in the declarations. So there was some response. The damage was caused, but nonetheless, well, it was expected. The system was heading in that way. The risks were mitigated, but some of them still remain until the reform of the Constitutional Court is completed. Thank you, Dennis. After the decision a year ago, the Venice Commission responded. They analyzed the decision, they criticized it, they explained that it lacks reasoning. However, they didn't tell us what to do. We cannot fire the Constitutional Court justices. They are protected by the Constitution, and this became suspended in mid-air. So the Venice Commission did not come up with a legal solution to the problem. Is there one? A law solution. Artem mentioned that there has to be a legal solution from the law. What is happening right now is the most possible thing to do that can be used to deal with the constitutional crisis that emerged as a result of the decision. Well, first of all, in all of the key reforms, the parliament keeps receiving opinions from the Venice Commission that are a great guarantee for future cases of the Constitutional Court. Until now, we haven't had a single case when the Constitutional Court would disregard or go against the best constitutional experts that Venice Commission has. That's on one hand. On the other hand, there's pressure exerted by onto the Constitutional Court by the public, which also turns out to be effective because not every public official, not every Constitutional Court justice will be able to juggle freely with Articles 8 and 6 of the Constitution, understanding that there are people outside the court rallying. You know, some say that there's democracy in the United States because, they are allowed to have guns. We do not allow guns, but there's still public oversight, which is a deterrence for those who have problems with common sense. There are legislative mechanisms also in effect. The gaps in the legislation are being dealt with, and the intention to cause damage doesn't arrive at the expected result. And the draft on the constitutional procedure, another thing to mention, and a few notorious Constitutional Court justices and their situation. This all is what led to putting that freight train to a screeching halt. And I think there are more than enough legal mechanisms out there to prevent those surprises from happening in the future. Thank you, Denis.
Напевно, найбільше
And actually, you communicate with the representatives of the Constitutional Court. You are actually a representative of Verkhovna Rada, Supreme Council of Ukraine in the Constitutional Court. So I've got plenty of questions to you. So what the Constitutional Court is being guided by, right? And why they are doing what they are doing? They are announcing some competitions. Calls. Topitsky was actually cannot perform his functions any longer. And you know, people do not know what Duralex Lex means. Hello. Let me start with what Mr. Olexandr Novikov started. I don't know whether you paid attention to that, but he mentioned that at the day of the decision of the Constitutional Court, we didn't know what the decision was about. And just the next day, we learned what was written in that decision. So, you know, a situation like that cannot be found in any country of the world. When Constitutional Court is passing something, is announcing something unconstitutional, but citizens of the country read it actually on the internet, that Constitutional Court passed this and this decision, just the next day, you know. And let me tell you that the previous week there was this very odious thing happening when there was this case. Just in 2 days, the Constitutional Court made public the decision they've passed. All this situation is a marker of what is happening in the Constitutional Court. And actually it shows us that without an appropriate procedure, it won't be possible to have order in the Constitutional Court. And here we speak about what? About claims, about all the constitutional claims, requests. It all happens in paper form, in hard copies. And I have plenty of complaints from the lawyers from all over Ukraine. They are saying that you need to inform the Constitutional Court that there is email and there are digital tools. Then in what way they have their documentation flow sorted out? Lawyers have to go to from all over Ukraine to actually get familiarized with all the documentation. They are not getting these documents via email. Then actually presenting judge, that's a very important procedural person. They are actually shaping up the understanding of certain case. They are actually, you know, playing a very important role, these very rapporteurs. And currently, everything is done manually through the head of the Secretariat of the Constitutional Court. Unfortunately, that's a person who does not have a crystal clear reputation, and actually the manual procedure is nonsense in 21st century if we are trying to move towards transparency of the Constitutional Court proceedings. And we offer to automatize it all, and all the decisions, all the acts of the Constitutional Court shall be in the registry of the Constitutional Court the very same day they were passed. Then the form of the proceedings, maybe you've heard, when they were actually dealing with that very decision on anti-corruption legislation, they've changed the form from oral to written one. And it was an unprecedented decision as well. I don't remember this in the Constitutional Court happening ever, when the form was being changed from oral to written. And it happened instantaneously. Just by chance, I learned that it had to happen. Then, with the representative of president in the Constitutional Court, we attended that very session. And, you know, they just closed the door in front of our noses. We wanted to say no, but they didn't let us to say no. We were against actually using that form of hearing. So, in the law, the constitutional procedure, we need to introduce some changes. But well, I believe it's not proper to close the door in front of our noses. Then the next huge problem would be disciplinary liability of the judges of the Constitutional Court. I believe you've heard repeatedly that Mr. Alexander Novikov was mentioning that he personally was resorting to the Constitutional Court with all the appropriate applications to hold hold the judges liable. But the thing is that as of today, the law, the Constitutional Court, which was passed in 2017, by the way, contains plenty of norms which contradict the Constitution. And this law was passed with a violation of the procedure. And, well, okay, that's the other story. So, according to the current legislation or law on the Constitutional Court may fail to consider this claims applications. The Constitutional Court is doing so. They are turning a blind eye to all these resorts. And just think about this. 4 judges of the Constitutional Court can announce any norm unconstitutional, any norm of any law. You will ask me, how come? Because there are 18 judges in the Constitutional Court, and they have to pass the decision by the majority. But there is this tool which is called constitutional complaint. It can be actually passed when the final decision is being made, and when a person, as regards which this decision was made, believes that the law by which the judges were using is unconstitutional. And as of today, we see plenty of claims of such constitutional claims. So this instrument, this tool, is being actively used. So as of today, according to the law, to claim certain provisions of the law unconstitutional, 4 voices would suffice. We are against that, and we believe that Senate can announce the law constitutional, meaning as such which complies with the requirements of the Constitution, by 5 votes. But if they want to declare something unconstitutional, then the Great Chamber shall actually decide on that, and only majority shall vote for declaring something unconstitutional. There was huge resistance towards this norm on the side of the representatives of the Constitutional Court. We were getting letters, and the Constitutional Court was claiming that we were limiting their rights and mandates by this. But during one of such meetings and such discussions with the judges of the Constitutional Court, when we were discussing this draft law, I told them directly that we were speaking not about mandate and rights, but about their fighting for their power. And I feel this connotation, I feel this mood. I am against such changes, and I'll be standing my ground. Though, from various sources, from time to time, I hear some other positions, and you know, the judges are saying you're going to block the activities of the Constitutional Court. But now, if you analyze how many decisions are being passed by the Constitutional Court of Senate, and what kind of decisions are these, whom they are protecting, you will see that everything will work appropriately, even according to the approach I'm describing here. So these are the key markers. I can talk for hours about this very law, but you know, in general, we were analyzing experience of foreign countries, in what way they regulate such procedures there. In plenty of foreign countries, the procedures are defined by the law, and actually that's the golden standard there, and they do not perceive it as an interference into the activities of the Constitutional Court there, because actually the Constitutional Court has to develop their own procedures, but within the framework of the current legislation. Yeah? Yes, I understand, Olga, but this draft law, at what stage is it now? Well, it's absolutely ready for their consideration, but the thing is that this draft law was introduced 1,200 amendments. We worked on all of them, and actually plenty of them were spam. You know, change into, for example, you know why they are doing this? They are trying to block the consideration of this draft law or bill. And I strongly hope that in the nearest future we are going to actually decide whether we will be considering 400 amendments a day and to overcome that spam, or we will use some specially designated procedure defined by Verkhovna Rada, that every faction defines 5 amendments which are important to them. We'll use that procedure and the bill will become a law. So we can clearly see, based on all those amendments, what factions are against this draft law, and it's very, very obvious what kind of vested interests they have. But as far as I understand, this draft law won't solve a problem. In what way they are appointing new judges of the Constitutional Court? Am I right? What is your opinion? You know, let me exemplify vividly here. In 2014, the parliament assigned Mr. Slidenko as a judge of the Constitutional Court. He was mentioned already. You know, I like this competitive procedure, and I'd like to tell you, if the Commission were selecting the candidates in 2014, Mr. Slidenko would rank first. I believe everybody will agree with that. And I personally, as an expert in the Constitution, will tell you, we were giving each other calls when Mr. Slidenko was appointed. We were so happy because we decided, you know, that was the huge festivity for the country, you know. And no one would believe that in 6 years Mr. Slidenko would be among the judges who would be voting for making the anti-corruption legislation null and void. So what I'm leading to, today we have an understanding in what way to actually balance this constitutional procedure. Let us do A, B, and then move towards regulation of the competition and competitive basis approach. You see, President has created the Commission selected candidates, and I'm not, as a politician, going to give some assessments here, because I'm as a politician here. But my colleagues actually assessed majority of the candidates positively, those who showed up on the list which was sent for presidential consideration. Well, that's a positive process. It's moving forward, but we have to understand, if we have the understanding of constitutional procedure, let us approve this draft law. Thank you, Olga. We've heard your opinion. Now I'd like to give the floor to Stepan Berko. Mr. Stepan, do you support the statement that constitutional procedure and the law on constitutional procedure will solve all the problems? What is your opinion? Do we need these competitive procedures and the competition we are currently having, whether we have decent candidates selected? 3 questions here. Thank you so much for all these questions. Well, in order to answer the first one, we need to think back about actually the recommendation of the Venice Commission. The Venice Commission gave us a plan, like a roadmap, right? And the key emphasis was made on the new competitive procedure. And it has to be transparent, and we need to involve, whenever possible, international experts, maybe civil society experts. There was another recommendation like that. And what is the most important? All new appointments shall take place according to this new competitive procedure. That way, Venice Commission, experts of Venice Commission believed we can boost trust towards this institution, because really the decision passed by the Constitutional Court undermined the back then low level of trust. And it was a high-profile case in the society. And unfortunately, the draft law on constitutional procedure, as they call it, does not solve this very problem significantly, because right you are, there are plenty of very good proposals in this draft law which pertain to in what way constitutional courts shall consider certain cases they are considering. And we need to say thank you to Ms. Olha for all the great work, because we see the great work done. That's a very important component. But I'm asking myself the question, if these tools were there 1 year ago, would it stop the Constitutional Court from passing that decision? And my answer to myself is no, because if there's decision is not substantiated and not rational, any requirements in the legislation would not be taken into account. They cannot stop passing of such decision. I believe it all depends on who is driving, who is at the steering wheel, but not on what technologies this car is equipped with. So a question, in what way to solve this problem then, and who is going to get into the Constitutional Court? And I believe the draft law on the constitutional procedure is a good, actually, pretext to introduce a certain mechanism. All the amendments were introduced to the draft law, and even the committee approved those amendments. The amendments were mentioning the single qualification committee for appointment, integrity checkup of all the candidates. So the recommendations which the Venice committee had given were taken into account there. And unfortunately, in August, in a month or two, the committee convened again, and they gave the red light to those amendments, saying they were not worked out appropriately. And, you know, they can be postponing it for ages, unfortunately, doing so, and the society is disappointed. No one is actually satisfied with half of a decision, if you were expecting an appropriate full-fledged decision. In what way to move forward? Well, to tell you the truth, the decision we've got 1 year ago, that's not a decision which was a shock. No one was expecting it. No. Today we've heard that the Constitutional Court for plenty of time is taking these irrational decisions, is passing the decisions, and this is happening because there we have people who are politically appointed, they are loyal to certain parties, and B, these are often representatives of the judges' corps, and they go there with one goal only: to protect judges' corporation from any I don't know, liability before the society. And this candidate shall be considered with the spotlight aimed at them. There is no other way. And the draft law on the constitutional procedure, well, today a lot of persons were saying that it's a good document, but still. What about the competition which is taking place now? Oh, yes, right, yeah. A very good question about this very competition. Well, this competition announced by the president, well, is doubtful from the viewpoint of its legitimacy. We don't understand what vacancies are we speaking about. President believes from his public position that Mr. Tupitsky and Kuzmina are the judges of the Constitutional Court. They were not appropriately appointed, but it's no different from the decision of the Constitutional Court about unconstitutional nature of appointment of Mr. Sytnyk as the head of NABU. And Mr. Sytnyk is still the head of NABU, right? And you know, there is this certain confusion. So this competition is not really legitimate, as I see this. And the president of Ukraine can appoint two judges to the positions which are not vacant. Well, we face a risk of delegitimization of this body, of this institution in general, and any future decisions of this body, because actually there is a risk that 4 judges will be aspiring for these 2 positions. We were actually asking this committee not to be in a hurry and at least wait for a decision of the Constitutional Court in this case. And we urge Mr. President not to do anything until actually everything is done in a constitutional way. But when this moment will will come. Mr. Tupitsky works till May next year, and Kateryna till September 2022. Of course, actually, they can, I don't know, announce that they are leaving the position. So maybe they will also be fired. So I don't believe that will be an option. No, they won't do it consciously, just because of their conscience, right? Anastasia wanted to comment, and then we'll proceed to the questions from the audience. Thank you so much. I'll allow myself not agreeing with Mr. Stepanov as regards the draft law on the constitutional procedure. I believe if the previous year we had the law on the constitutional procedure in a reading as we see it now, then we would have one very, very significant difference. The decision of the Constitutional Court, based on which we woke up the next day with the system of prevention of the conflict of interest. Well, on the next day, we woke up to the reality where there was no such procedure, and the Constitutional Court mentioned some very good instruments were unconstitutional. We would not have this situation because the draft law stipulates for one very important thing, among others. Impossibility for the Constitutional Court to announce a norm unconstitutional at once. There shall be some time, right? And there need to be time to digest this decision, and there need to be time for some discussions, right? And only then these norms or these decisions will come into force. That's not a proper situation. It's not normal. And as to me, it would make a difference. It would be great to have this draft law, at least in that form as we have it now. And, you know, it's not possible to suspect that I'm not a proponent of competitions. In the judicial reform, majority of amendments on strengthening of the role of the independent experts are my amendments. I'm not against. I want to have strong candidates aspiring for the positions of the judges of the Constitutional Court. But actually, due to some objective and subjective reasons, we cannot agree on the model of that competition. When I'm saying I'm not speaking about servant of the people faction, but I'm speaking about the parliament in general. And we cannot agree now. It doesn't mean for me that we shall not be passing this law on the constitutional procedure in general.
Stepan, then the Minister of Justice, and then Q&A. Unfortunately, the responsibility of the Constitutional Court to delay the entering into effect of the decision, we had situations when the Constitutional Court would give Parliament the time to respond. In particular, that was in the case of criminal liability for miscarriage of justice, if I'm not mistaken. But the Parliament did not respond in any way to that. Well, what's the difference there then? It's, you know, comparing colors. Some like orange, others like pink. Well, that's on a personal note. My second point is that I disagree that the Parliament had a sidelight discussion about the model of the competitive selection of the Constitutional Court Justice, because the amendments about the selection procedure of the Constitutional Court Justice were discussed at the meeting of the committee for 10 minutes only. Correct me if I'm wrong. I don't think we can call this an open, public, professional, inclusive procedure of discussing the most important element in the draft law that can help find a solution to the crisis we find ourselves in. I think that the committee did not do their job properly. The committee can actually resolve it. Until the draft law is in the plenary session, there still could be discussions, there still could be ways to improve the model, and then there could be a strong, powerful solution, not something that is halfway, that simply delays or puts the problem on hold. Denis, the Venice Commission, as Stepan shared with us, said that there should be an independent, unbiased selection procedure to the Supreme Court. Olha says that she is not really a believer those selection procedures. I was under impression that you had some doubts about the selection after Slidenko. We said that if in 2014 we had a selection, if there had been a selection procedure in 2014, Slidenko would have ranked first in that selection. But you're still a believer. You still believe in the selection procedures. Yes, Denis, the selection procedure to the Constitutional Court, is that a legal, political and legal decision? Do we need to specify selection procedure to the Constitutional Court in the law? If yes, what kind of procedure should that be? Well, I have to disappoint you. I'm not following the selection procedure to the Constitutional Court. It's outside the scope of my competence, so just some news I'm reading in the media. But I want to make a different point. Well, the procedure itself and the competitive selection procedure are important. Procedural aspects are very important, and they are more important. Well, even though we're lawyers, this is a matter of psychology. And for decades, we've known through scientific proof that there's no freedom of will. Any kind of behavior is response to external influence. And some circumstances might prompt Slidenko to make a bad decision. This is a scientific fact. This can happen. So business processes are most important. Automation, transparency, people as an element to a business process is very important. And competitive selection and understanding of the candidate, of their responsibility is also important, but that's not 50% of success. This is part of the business processes that have to be up and running in the Constitutional Court. And the selection procedure is not about people as much as it is about procedures. This is the interpretation of how the court should be operating, what approaches should be used. Thank you. Questions from the audience. Dmitro Filuk, Union News Agency. I have a question about the recent statement that was made by Mr. Danilov, who said that he personally wants Ukraine to be a presidential republic. Well, I would say this was testing the waters by the presidential administration. If presidential administration decides to return to the presidential republic, will the Constitutional Court and its current composition on other composition to approve of these suggestions from the presidential administration? Will they give it green light? Well, I'm sorry, I cannot think of a way to answer the question. We, are not that close to the Constitutional Court. Well, presidential administration, putting out the feelers. Well, 99%, That's improbable. They're doing it in a different way, as far as I know. Mr. Danilov, as far as I know, was sharing his views, and this is very in line with his office. He's the secretary of the National Security and Defense Council. He wants the decision to be enforced promptly, immediately. So that's very typical of him. But the things he said, that's unrealistic. So therefore, I wouldn't comment it as a plan. And I have a follow-up question. The situation that was just described, the Tupytsky case, as far as I understand, the first instance, the case was won in the first instance, and the case with the appeals. The case to revoke the appointment with Zelensky. And the thing is that the powers of the justices expire next year, so is there any point of trying to do something now? Well, the uninterrupted work of Kosminin and Tupytsky in Supreme Court, and it would increase the risk of us talking not the crisis that happened a year ago, but discussing a tiny little crisis that happened a year ago that grew into a major crisis. We would be discussing a completely different kind of crisis. We would have found ourselves in a very different situation. And this freight train or steamroller that started its movement way back in the past would have continued. It's grinding. Vyacheslav Sudova, Юридична newspaper. I have a question to MPs about the constitutional crisis. We know that Tupytsky's case had certain pressure from a State Bureau investigation. There were some requests for documents. What do MPs think about the problem? Maybe that shows distrust in the decisions of the Great Chamber. What do you think? What's the pressure here? The panel of the judges couldn't open the case pursuant to constitutional submission about constitutionality of the dismissal of Tupytsky and Kosmin because one of the members of the panel recused himself, and it took them 6 months to find a judge who would become a part of the panel. They needed this to open a case. And last week, only last week, the case was open. So, well, it's not so much a pressure, but a free interpretation of the law of the Constitutional Court, which has been happening constantly in the Constitutional Court. And the Constitutional Court has their ideas of procedural terms. And there's a submission, constitutional submission from the Parliament about the draft law on amendments to Constitution dated 19th of March of this year. The case hasn't yet been opened, even though these cases have to be opened immediately, and there should have been a decision in a month after submission, but the case hasn't yet been opened yet. The Parliament made a submission to the Constitutional Court. The Constitutional Court has a reality of their own. So pressure is not the right word here, I think. But there are criminal cases. So what point do these have? The purpose of the criminal case is that there's suspicion that someone committed a crime. That's abstractly speaking. Thank you. I have one more question about the judiciary reform, not the anti-corruption reform. It is being unblocked. There are important draft laws that were passed last summer. The president declared this a major victory. International partners agreed with that. However, recently, as far as I know, the Supreme Court made a constitutional submission to the Constitutional Court about the constitutionality of the judiciary reform that is yet being born. Can the Constitutional Court kill an unborn child of the judiciary reform? And what do we do to prevent that? Well, the law on the constitutional procedure, will that help resolve it? Or criminal cases, some criminal cases might help with that. So what do we do? What are the threats and what do we do? And let's make it the final question that will help recap our conversation. Minister Maluska. Well, I'm all in favor of a strong constitutional court. So, phrasing the question, how do we prevent the constitutional court from devastating, destroying the laws, is not the right way to put it. We have to create the situation preventing the court from stating the laws. The judiciary reform, we already have opinions from the Venice Commission. There's a law on the constitutional procedure that will be adopted before, hopefully, the constitutional courts start doing something with the judiciary reform. And if there is time given to rectify some problems, that will be good. So destroying the entire structure of the laws on the High Council of Justice, High Qualification Commissions, is something that I don't think is going to happen. But the thing is that these draft laws led us into an area which is not yet quite explored through the practices of other countries. So we are in certain risky area, since these tools in Western countries haven't been used much. And the Venice Commission itself says that Ukrainian situation is unique, which means it requires unique tools. I think that the probability that the Constitutional Court is going to dismantle the judiciary reform, the laws that were adopted last summer, the chances are not that high. This is just, an educated guess. It's I could only venture a guess that there might be a decision or not. Is the Constitutional Court a threat? Yes or no? Well, there's a decision of the National Security and Defense Council, which say that no. Is the Constitutional Court a threat about the judiciary reform? The Constitutional Court has 50 constitutional submissions pending. So I think that until the Constitutional Court finally finds time to process the submission about the judiciary, hopefully we will have the judiciary reform implemented. That's half-joking answer to the question. On a serious note, of course, it cannot happen when we learn about the decision of the Constitutional Court 2 days after it. And the provision of the law was declared unconstitutional as of the day of the court decision, but the decision was made public 2 days ago. The Senate of the Constitutional Court passed this decision, and there's a need for the proper procedure. We have to pass a law on the constitutional procedure, and without it, prognosticating what is going to happen is just, well, the draft law is ready. As soon as we figure out what to do with 400 amendments, as soon as we have a political decision about these 400 amendments, we are more than ready to adopt it. It's ready for the hearing. And the question is, the Constitutional Court considers being a threat to national security. I think that the risks to it being a threat are still there. The very fact that we have to, forced to venture a gas and to come up with assumptions, the situation when we cannot find answers given the procedures in the Constitutional Court. This situation in and of itself suggests there are problems in the practices of the Constitutional Court, and I think that we have to pass along the constitutional procedure for the reason that, given the previous practices of the Constitutional Court, nothing prevents them from rendering a decision tomorrow, a week, or next week, and nothing protects us from learning today that there was a decision 2 days ago. And this means that any reform or any law runs the risk of not withstanding until we have a new selection procedure and have new selection and new judges. In this discussion, what's important, the very procedure itself or the competitive selection procedure? Well, that's a question about what's more important, left leg or right leg. I think there needs to be a law on the constitutional procedure, one way or another. Stepan. Well, I think we need to have two legs to stand firm, not choosing between either one. I'm both for the constitutional procedure and for the selection procedure. About whether the Constitutional Court is a threat to the national security, well, some of the court justices are a threat to the national security, and the absence of the high-quality selection procedure of the Constitutional Court justices is the threat to democracy and constitution. What about the judiciary reform? Are there threats there? Oh. Is there a risk that the Constitutional Court is going to revoke it? If you read the Constitutional Court decision of last year about the law 193.9, no reasoning, and dismantling of the reform, I don't see that anything has changed since then. What is the public going to do if the Constitutional Court renders such a decision? I think that the public, well, I can only speak for our organization, we will do our best to prevent this from happening. Picketing, rallies. Thank you, everyone. We're actually on time. It's 5 p.m. sharp, and we are concluding our discussion. I would like to thank our esteemed speakers. I really want the constitutional procedure adopted. I really want to see the selection procedure that would help us deal with the threats that might still be there, and hopefully all of us will partake in reaching that goal. Thank you very much.